Good morning and welcome to Court TV Live. I'm Cody Thomas in for Ted Rollins this morning. Thank you so much for joining me. Now we're tracking three major trials this morning here at Court TV. First in South Carolina, proceedings have begun this morning in a motions hearing ahead of the Alex Murdaugh retrial. Now his double murder conviction was vacated by the South Carolina Supreme Court in May, and his defense team is asking for his trial to be moved to Charleston, which the state is opposed to. We'll take you back inside that courtroom later this hour. Also, in New York, Luigi Mangione is expected to be in federal court this hour for an unscheduled emergency hearing. Now, we don't know for sure what's on the docket, but there is some reporting that it could be a plea deal of him pleading guilty to his federal charges. We have a reporter there, and we'll bring you that update as soon as it's over. And in Massachusetts, jurors have the day off in the Lindsay Clancy triple murder trial. The former labor and delivery nurse is facing murder charges in the strangulation deaths of her three children in January of 2023. Now, testimony resumes on Monday morning, but we expect the Commonwealth will rest their case at some point, and then the defense will begin their case. Of course, that's where we begin this hour. Lindsay Clancy facing triple murder charges in the strangulation deaths of her three children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan. Her defense argues that because she was in the throes of a psychotic event, she was not criminally responsible. Yesterday, the lead investigator read notes that Lindsay Clancy wrote on her phone in the weeks before she killed her children to the jury.
I'm sad and depressed because I am not able to parent my third child like my first. I want to treat any one of my babies like my first, but I know that's not a feasible possibility. I'm sad that I stopped breastfeeding. I feel not as connected with Cal now. I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them. I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them, so we had a pretty rough evening. I want to feel love and connection with all my kids. I'm also probably having a bit of an internal conflict because my whole life I wanted to have a lot of kids. I still don't want Cal to be our last, but I have a lot of figuring out to do before I have another.
Joining me now to discuss this hour, trial attorney, my good friend, Krista Ramey. Krista, always great to see you and have you on the program. Thanks for joining us this morning. Krista, let me get your thoughts on that piece of testimony there, the notes on the phone. We've also heard about, journal entries that Lindsay Clancy had written. As I listen to some of this testimony, to me it sounds like a woman who was, because you got to remember this was weeks, over a month leading up to when all of this happened. Sounds like a woman that was on the rapid decline mentally versus a psychotic break in the moment. Talk to me about your thoughts.
I push back on that a little bit. Mm-hmm. I think that what was happening is that there was a spiral for sure that was happening over time. I think you're right there. But the psychotic break, the theory is that was caused by the narcotics that were prescribed and the misdiagnoses that occurred. So if she had been properly diagnosed, I think is what the theory is, with bipolar disorder instead of depression, severe depression and anxiety, then the different drugs would have been prescribed. And so the drugs that she was prescribed were contraindicated for bipolar disorder. So hence this drug-induced psychosis that occurred, psychotic break that occurred at some point, in the day of, I'm assuming, of the killings of her children.
Krista, let's talk about this. At this stage in the trial, we're 3 weeks in, it seems that prosecutors are essentially kind of building this wall of these contemporaneous observations, for lack of a better term. We have doctor after doctor, counselor after counselor showing Lindsay was depressed and struggling, yet some of them say they didn't see psychosis, saying that she did have elements of linear thinking, remained organized and reality-based. I mean, how difficult is it going to be once the defense, their case starts, for their experts to knock down this wall that's been set up by the prosecution now?
I think that the wall that's set up by the prosecution actually can cut both ways. So when you talk about, all of these, doctor's visits, but you also have, these searches about, from both her and her husband that was put on yesterday about, different types of drugs, different types of mental illnesses and conditions. She was very concerned. He was very concerned. And by all accounts, She loved her children. Even in her own diary notes that were read into evidence, she loved her children. She wanted to be a present mother. She wanted to have her youngest feel like, her first did. And so this is not the signs. Where's the motive? Why did she do it? The way that the prosecution's theory of the case is that there was a calculated plan that was laid out, that was developed over time. And they really haven't shown that. They've shown that there was concerns. They put on evidence a search for an artist that died by suicide, but that then on cross-examination was clearly done by her husband and not by her. It's not adding up. I think the wall is not as strong as they think it is. And a lot of really good evidence is coming out on cross that it appears, to me at least, that the prosecution is hiding. And I think that that's why they're doing such an effective job on some of these cross-examinations, getting in some really good evidence favorable for the defense.
Yeah, Chris, the point I brought up earlier this week, actually, it seems like the prosecution is kind of trying to throw things at the wall now and seeing what's sticking, which I feel like is affecting their credibility. And one moment of contention I'm thinking about is how last week, I believe, when they were going on and on, doubling down on this insinuation and this idea of a staged suicide, going so far to the point to call a bunch of witnesses, take up a few days talking about this, blood spatter experts talking about how, there was contact evidence of the blood and streaks going down the side of the house, insinuating that maybe she didn't jump out of the window. She, hung down like Spider-Man, I think is how Kevin Reddington kind of alluded to it once he got there talking about it. But then there was, outside of the presence of the jury, there's some arguments going on where the prosecution kind of doubled back like, hey, we weren't exactly saying it was staged. We're just saying that, and this is the phrase that got me, Krista, there was insufficient methods as to how she went about it. And in my head, I'm thinking, on what scale? Who's according to whose ratings are these insufficient methods? I mean, we know the woman jumped out of a window and now she's paralyzed. To me, that speaks more volumes than whatever they're trying to insinuate here.
Yeah, I mean, one of the things, too, to your point, is that the wounds were not deep enough to have a lot of bleeding at the scene. Well, it was because her body temperature was so low because of the fall and the paralysis, and that she was, in really bad condition at that time. So as soon as her blood pressure went up, and as soon as her temperature went up, then the wounds started to bleed again, and you realized that they were pretty deep. They weren't superficial. So she was, I think that the evidence is pretty clear. She tried to kill herself.
Absolutely.
And it was unsuccessful.
Absolutely. Krista, we have a friend joining us now, our friend trial attorney Silva Mergadician. She arrived better late than never. We love to see her. Silva, great to have you on today. Of course, we're talking Lindsay Clancy here. Just talk to me about your overall thoughts of the prosecution's case so far, Silva. Me and Krista were just saying that, it seems that the walls that they've built might not be as strong as they may think they are compared to the defense's case that is to come up. Kevin Reddington is masterfully defending his defendant in this trial to me. What are your thoughts on the prosecution's case so far?
Well, Cody, I adore you. Brilliant one. Thank you so much for having me. And Krista, looking beautiful and brilliant as always. Look, you guys, I think it goes to what strikes me so much. There's a lack of compassion with the prosecutor that I also think is really not a good look for her, especially the way that she's talking about the evidence and her own witnesses. And it also shows the strength of Reddington. This is one of those cases, Cody and Krista, where the expertise of actual guided cross-examination, he knows his case better than anybody in that courtroom. And it is so unbelievably evident. And what I love about Mr. Reddington is how I think I try to do my cross-examination as a defense attorney. It's not only expertise of what your case is about, but compassion of your client. And that is coming out so much. But Cody and Krista, his cross-examination yesterday was absolutely brilliant, because what he did was almost show that the prosecutor in her direct examination was purposely trying to hide evidence. When she was putting excerpts and not showing the whole story, that shows to the jury that the prosecutor is not transparent. And one of the best things a prosecutor can do in their case is say, look, we have nothing to hide. This is all of our evidence. We don't care what's being asked because we are absolutely factual in what we're proving. And I think Reddington did an amazing job trying to show, look, this prosecutor isn't showing you the whole picture here. The fact of the matter is Patrick was actually logging onto the computer, and it wasn't even my client who was arguably there. I almost feel, Cody, like Reddington is proving his client innocent rather than waiting for the prosecutor to prove his case beyond a reasonable doubt. Like, in other words, I just think brilliance.
And the thing about it, Silva, in a nutshell, context matters, credibility matters, and most importantly, especially in a court of law, transparency matters, especially on behalf of the prosecution and the state. And you know the jury is picking up on a lot of that minutia, a lot of that nuance. But of course, we have plenty of weeks of trial left to go here. The defense hasn't even began their case yet, but expecting that next week. So it'll be quite a ride as this continues. But Silva, Krista, stand by. Folks, more from South Carolina in just a moment. And in New York, we're live outside the federal courthouse where Luigi Mangione is scheduled to appear at an emergency scheduled hearing. Is there a plea deal in the works? Brian Thompson's family is reportedly in the courtroom, and we have a reporter on site. We'll have a live update as soon as that hearing ends. Keep it here on Court TV.
Do you love Paul?
Did I love him? Like no other. He and Buster.
Do you love Maggie?
Oh, more than anything. I love Maggie from the first time we went out.
Did you kill Maggie?
No, I did not kill Maggie. I did not kill Paul. I would never hurt Maggie, and I would never hurt Paul. Ever. Under any circumstances.
That was Alex Murdaugh testifying in his own defense during his first trial for the shooting deaths of his wife Maggie and their son Paul. Now, Murdaugh was convicted, but the South Carolina Supreme Court overturned the verdict and ordered a new trial after the defense argued that the Colleton County Clerk of Court had tampered with the jury and that Alex didn't get a fair trial. Let's go back inside that courtroom now for more of today's proceedings.
I'll take care of that. You don't need to worry. Neither one of you. All right, next motion is going to be the state's motion in limine to exclude evidence of the polygraph. Let me hear from you, Mr. Waters.
Yes, ma'am, Your Honor. Yeah, this was just a prophylactic motion in limine that we filed prior to the first trial. And again, the case law is cited in there. I'm happy to detail it for Your Honor, but obviously the case law is very clear in South Carolina that polygraphs are a no-no, and that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual notes that it's not a lie detector. What it does is record physical responses that in the subjective opinion of the examiner may indicate deception, but that deception may or may not be related to concerns of guilt or innocence. And that's why the courts have always rejected those, in addition to the fact that they go to the heart of why we have courts and why we have juries, and that's of course for the ultimate determination of the truth of the matter. And so obviously from the state's perspective, if ever there's a polygraph issue or there's an interview that occurred after polygraph, we are rock solid to make sure that witness and that officer or whatever does not say the P word out loud, and that's just been the general rule. And and this is the way I do things, just like we did the financial evidence last time. We laid all our cards on the table, did a long, extensive hearing. There was no gotcha moments or anything like that, and we just asked for the same thing, that there be, just sort of an in-camera ruling and an instruction that the polygraph word is not to be mentioned because, again, it can be hard to unring the bell.
That's right. Let me hear from you, Mr. Harpootlian or Mr. Griffin.
Please, Court, Your Honor.
Sure.
So, generally, Mr. Waters is correct. But, and let me point out to the court, and I'll hand up a copy of the case. It's the state versus Henry Eastwood, which,
It's the Eastwood case? Is that what you said?
I'm sorry?
It's the Eastwood? I've got a copy of it. Go ahead. No, I've got a copy.
So, as you know, if you've got a copy of it, the Supreme Court said there's not an absolute ban. There are circumstances under which a polygraph could be used. I mean, again, it is not a lie detector, but the question is, if somebody was confronted with the fact that they failed a polygraph, did they give it? I mean, in this case, did they give it a confession? The Eastwood case, it was a confession gotten. In this case, and we want to argue this more fully, depending on whether or not this witness is called, Eddie Smith, who, as we've already understood, was charged with a whole bunch of stuff, had a proffer agreement with the state, and the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdaugh? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're going back through. I will tell you, Mr. Murdaugh passed a polygraph, flying colors. So the same polygrapher. So it may play a role in this trial. I'm not willing to concede that not under any circumstances can a polygraph ever be used. I'm just giving you this example of Eddie Smith failing the polygraph and them relying on it to cancel his deal. Now, that's what our understanding is from the limited documents. They never called Eddie Smith in the first trial, which we were shocked by. But should they call him in the second trial, we may want to go into this. So I would ask you not to issue an order prohibiting any mention of polygraph with this guarantee. We would not mention polygraph in a courtroom with a jury until given permission by Your Honor to do so.
All right, well, let me tell you, anything else from the Mr. Waters?
Well, Your Honor, just to correct one thing, there's never been any sort of deal with Eddie Smith. A proffer is not a deal. It says in big bold letters, this is not a cooperation agreement. It's only, essentially a first aid provision. Again, polygraphs can be an investigative tool, but they are never, I never base decisions on them. And frankly, in my experience, I found them to be wrong or for people to indicate DI for other emotional reasons than them to be accurate. This is why they're not ever relied upon in court. The case that they cite is a completely different issue where in that particular instance, the defendant wanted to bring up the fact that he had been given a polygraph and was told by the examiners he was lying as part of his defense in presenting an expert on false confession. And that is nothing that we have in this particular case whatsoever. And in fact, if you look at the cases that we cite in the memo, Your Honor, a prime example of what the Supreme Court has ruled was there was one situation, and give me 1 second, I'll find the case. That would be State v. Counsel, which is the seminal case on that. And in that particular case, there was another witness who took a polygraph on, were you present, were you involved, and DI was shown, deception indicated was shown. And of course, the court said that because a polygraph cannot reliably show truth, it's of no assisting to the jury because it doesn't show anything. So that's a vastly different situation, more akin to what we have here, where the Supreme Court has already said no, than the situation in the Eastwood case, where that false confession and this aspect of it was crucial to that expert's opinion.
Okay, thank you.
Very, very briefly. It was a proffer agreement. And the proffer is, you're going to tell us stuff, and if you pass the polygraph, we can go to the next step, which would be perhaps giving him something for his testimony. They were using it as a screening device, no question about it. But he failed the polygraph, so he didn't get the deal. He's right, he doesn't have a deal as far as we know. And the reason he doesn't have a deal is he failed the polygraph. Now, whether we get to talk to the jury about that 9 months from now is an issue altogether different. But all I'm saying is we would ask you not to issue an order blanket order prohibiting the mention of polygraph, although I will concede I would not do that without having free trial, the in-camera hearing of some sort and getting clearance from you.
Well, that's going to be my ruling, Mr. Harpootlian. I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial. You understand?
Well, I think, Your Honor, you probably shouldn't threaten mistrial. You should threaten contempt.
Contempt. Yeah, you don't want me to hold you in contempt, Mr.
Well, I don't want you to
Harpootlian.
mistry the case.
And I might mistry it if you start screaming polygraph. So without letting me know beforehand. You understand? I want to make sure everybody's on the same page.
I got it. I think I suggested it. I agree with you. I just wanted you to know there are circumstances, and that's one where we may seek to do that. We're not going to do it without getting your approval, and
Perfect.
that may come up in the context of his testimony. He may say something that.
I mean, you never know what happens at trial.
Right.
I'm just telling you, right now, I'm telling you, a polygraph is not admissible. If you're going to bring it up, you need to let me know first, and then we'll have an in-camera hearing.
Thank you, Your Honor.
Any objection, Mr. Waters?
None at all, Your Honor.
All right, then let's move on to the next motion. The next is the state's motion in limine to allow the state's use of the defendant's prior testimony in retrial.
All right, let's bring in our guests still with us this hour, trial attorneys Crystal Ramey and Silva Megadici. Silva, what do you make of that ruling there about the polygraph? They were talking about how this cousin Eddie, remember cousin Eddie,
Yes.
he failed his polygraph when asked if he killed Maggie and Paul. They say that Alec Murdaugh passed his with flying colors, but the judge obviously saying this cannot be brought up unless you get a ruling outside of the presence of the jury beforehand, so everybody can be on the same page. What are you making of this whole thing?
Absolutely obvious, Cody. This is the ruling because we all know that polygraph test results, they are not reliable. And she made the obvious choice. You cannot have that in. I understand the desperation of the defense attorney, right? Harpootlian. He absolutely wants this in because that in itself can be reasonable doubt. But these tests, Cody, they are so unbelievably unreliable. They are never allowed in a court of law, and she made the right ruling. So he, with expert cross-examination, he'll be able to elicit reasonable doubt in a way to have the centerpiece on, Eddie Smith. But he doesn't need the polygraph test to do that, and it will never be allowed in. So it's a dead argument.
Crystal Ramey, I want to get your thoughts on the same idea here.
I could not agree with Silva more. I mean, this is the only path for the judge to do. And what the judge is doing here is probably, smarter than a lot of judges would just say, no, never, under no circumstances. What this judge has done is very thoughtful because you say, look, let's see how the evidence comes in. I can't make a final decision until I hear it. And if you think that there is a reason why it's relevant for some purpose, some proper purpose, that's not to prove that someone is telling the truth or not, so it has to be for a different purpose, then we'll allow it in. Otherwise, no. And, it's the same. This happens a lot with various types of evidence that is not admissible to prove a certain thing, but it might be admissible to prove another thing. But you can't just blurt it out in front of a jury because then all they see is that thing. In law school, it was like the pink elephant they taught us. You can't unsee it.
Exactly. Well, my friends, stand by. We're going to have more from South Carolina in just a moment. But also, folks, in New York, we are still live outside the federal courthouse where Luigi Mangione is scheduled to appear at an emergency hearing. Is there a plea deal in the works? That's the big question. Victim Brian Thompson's family is also reportedly in the courtroom, and we do have our own correspondent on the ground there, and we'll have a live update as soon as that hearing ends. And also looking ahead to Monday, opening statements are expected to begin in Las Vegas in the Tupac Shakur murder trial. A jury of 10 men and 6 women has been selected to hear the case against Dwayne "Keefy" D. Davis, the accused mastermind of the shooting. We'll have a camera in that courtroom, and we'll bring it to you live right here next week on Court TV. Welcome back to Court TV Live. I'm Cody Thomas, and we're live this hour in Lexington, South Carolina, where Alex Murdaugh is in court for a motions hearing ahead of his upcoming retrial for the murders of his wife Maggie and their son Paul. Now, Maggie and Paul Murdaugh were found shot to death by their kennels at their home in Colleton County, South Carolina in June of 2021. Alex Murdaugh told police he found them there when he returned to the house after visiting his mother. But it was then later revealed that Murdaugh had been at those kennels with Maggie and Paul when police found a video on Paul's phone that had Alex Murdaugh's voice on it. He admitted to that on the stand during his first trial. Damning testimony then, and likely going to be damning testimony in round 2, coming up in April of next year. Let's go back inside for more proceedings.
Let me hear from you, Mr. Waters. I've done a lot of research on your motion.
Yes, ma'am, Your Honor. Obviously, at the first trial, Mr. Murdaugh, who of course had given multiple statements to the police, in which he said he had never been down at the kennels. He had told all his law partners, all his friends, all his family that he had never been down at the kennels either. And obviously, during the state's case in chief, we presented witness after witness who knew him very, very well, saying 100% that's his voice on the kennel video, which again was taken at the scene with the victims and according to the timeline just moments before they died. And so he ultimately, with the full waiver with Judge Newman, said, I'm going to testify and I want to testify. And of course, right out of the gate, the first series of questions asked by Mr. Griffin on direct examination was an explanation of why did you lie about being down at the kennels. It was the most important issue in the case at that point. Obviously, as a general rule, under Harrison, a defendant's testimony at a former trial is admissible, and I'll get to the statute in a second. And then I'll also, of course, under Rule 804A1, it would be admissible, of course, based on unavailability, assuming that he would refuse to or exercise his Fifth Amendment right at a second trial. The issue, of course, boils down to the statute. And of course, the statute says that the testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case except upon an indictment for perjury. And of course, our position in that is that this is the same criminal case. This is not an other criminal case. It's the same indictment. It's the same allegations. It's the same case that we are doing. There's no question that we are starting the evidentiary presentation again from new, but that doesn't change the fact in the plain language of the statute that this is the same criminal case. And we cite
That's the critical distinction for the statute. Either you're in the same case or you're not.
I agree, and we cite Tucker for that proposition. Now, I do agree that Tucker's a little different. It was a death penalty bifurcated case, and that the guilt phase was affirmed and the sentencing phase was reversed. But the court clearly said there that during the resentencing phase, that prior testimony was admissible because it was the same case. Now, the defense obviously argues that because of the Supreme Court's guidance on the financial issues, that ultimately his decision to testify is somehow impelled by that, and we would respond to that in two ways. Number one is the first thing is very clear that the most important reason for him, quote, I want to testify, is that he had to explain that kennel video, which again was the most important issue for the defendant to testify. Secondly, as we look at the opinion, and obviously I know you've deferred on the motive evidence, and we'll get to that at a later time, of course. But the Supreme Court, while saying that perhaps the trial court let the state go too far with that evidence, the court did say that the court appropriately ruled the evidence admissible under 404 and did appropriately admit at least some of that evidence. So ultimately, depending on how Your Honor rules on that mode of evidence, admission of any prior testimony, should the state decide to do so, could be very much tailored to whatever the appropriate parameters are based on this court's ruling as to the extent of that testimony.
Right, I think it would go along with what financial crimes are allowed in at the time of trial. Absolutely.
Absolutely, and the state certainly understands that and is willing to do that. And then even aside from that issue, clearly whether it's impeachment of this defendant should he testify again, or if the defense were to present a new theory through evidence that would be refuted by this testimony, I think that the law is very clear that then it could be used for impeachment to sort of, if they change tack, then it would be fair game regardless of the issue of the statute.
Okay. Who's going to argue that?
Mr. Barber will address.
Mr. Barber, come join us.
Good morning, Your Honor.
Good morning.
Of course, we oppose this motion on two grounds, a statutory ground and a constitutional ground. And I would like to address the statutory one first on the generally accepted principle that if a constitutional issue could be avoided, that you should rest on statutory grounds. And the statute here is 1911-50, which, as Mr. Waters said, prohibits using his testimony in another criminal case. And so we're concerned on what is the same cases versus another case. At 10:23 a.m. in this hearing, Mr. Waters, standing at this podium, said, quote, "This is a new case." That was his statement on behalf of the state. On a different motion, he said, quote, "This is a new case." Now, for the purposes of this motion, it becomes, again, the same case. The defense's position is that a trial de novo is another case, that is the logical, rational conclusion from the statute, that the purpose of the statute is to protect the ability of a defendant to testify in one criminal case without a broad, irrevocable waiver of his Fifth Amendment rights. The state, as far as I can tell, takes the position that the indictment number controls whether this is another case or not. Not anything substantive happening in a case. And I would point out that there's not a single case in which, with a trial de novo, because of an error by a state actor, not the prosecution, but certainly a state actor, that constitutes irrevocable waiver of the defendant's Fifth Amendment rights. You know, Tucker is the closest case. As Mr. Waters conceded, it's not really applicable. It's a resentencing on the same conviction. Here we're having a trial de novo, and everything is new. As the court just went through with all those other motions, it's a new case. Even the protective order has to be redone. Everything is new. All the motions in limine have to be redone. The one thing that is eternal and cannot be changed from the previous trial is one witness's decision to testify. That Fifth Amendment waiver is the only thing, according to the state, that's not waived. For purposes of the statute, we suddenly become the same. And before getting to the constitutional infirmity of that, as Your Honor knows, we filed a motion to dismiss the indictment shortly after this motion. It was responsive to this motion. If the state, it's a reductio ad absurdum argument. If we're really going to take the position that it's not a substantive question whether this is the same case or a different trial, well, if it's the indictment numbers under thrift, we clearly meet the standard under thrift for dismissal of the indictment. Now, is that a waste of the court's time? I would say yes, because they'll just go to a grand jury and re-indict it. You know, but if we're going to put substantive import on the indictment numbers, the arbitrary indictment numbers, well, the grand jury, we have testimony from the first trial that the grand jury was presented evidence that the state admitted in its reply closing argument was incompetent, which the witness also admitted was incompetent. We have, if you look at that very lengthy motion for sanctions that's still pending, it's a colorable claim of misconduct. I would point out in thrift, the Supreme Court explicitly held there was no misconduct, but because there's a colorable case for it, which is the least possible burden, well, fabricated evidence is a colorable claim of misconduct. Okay, is it prejudicial? Well, it would be the only direct evidence linking the accused to the crime, the only direct forensic evidence, something that would prove his guilt, that must be prejudicial. So we meet the thrift requirements. The indictment should be dismissed. They should have to go back and re-indict it. We'll get a different indictment number. It'd be right back here with a different case if that's really their position, that a trial de novo is not another case. And this is just a statutory argument. There is, of course, a constitutional argument, which is the Harrison argument, which is that because he was testifying to address evidence that was ruled to be inadmissible, that his Fifth Amendment waiver cannot be held in this new trial. I mean.
All right, more from South Carolina later, but in New York, Luigi Mangione is inside the federal courthouse where he has told the court he is prepared to plead guilty to the federal charges of stalking United Healthcare CEO Brian Thompson. Thompson's family is reportedly in the courtroom, and we have our own reporter on site. We'll have a live update as soon as that hearing ends later today. Keep it here on Court TV.